Well, hello, everyone. Thanks so much for joining us today. My name is Shelby Hayes, and I'm the marketing director here at Evans and Davis. And we have attorney Omar Zantut with us today. And he's who you're mostly going to be hearing from on this topic. But I did want to jump in here and kind of get us started and let you know what you're in for today. So we're talking about simplifying the Oklahoma probate process. So this entire presentation and our entire time today, about 30 to 45 minutes, we'll be talking about Oklahoma specifically and about the probate process. We really want to encourage you to ask questions. That's what we're here for today, is to help you understand that process and understand how Omar and his team can help with that process. So please feel free to send in questions as you have those. We'll answer them throughout the presentation, and then we'll also have time at the end to make sure that we answer those questions for you as well. So if you have not been on a webinar on Zoom before, just a couple of things to know here. We cannot see or hear you, but we do want you to be asking questions. So down at the bottom of your screen, you should see a button that says chat. If you click that, then you can send over questions to us and we'll be able to get those answered. So certainly utilize that feature, but if you're having lunch or you've got something else going on, no concerns. We won't be hearing you or seeing you during this time. Now, it does look like on my end, we're having a little bit of trouble. So Omar, please jump in and take over if that's showing on your end too. But
I'm not seeing any trouble, but honestly, oh, there we go.
awesome. My screen's being a little crazy, but if it's not coming through on your end, then that's
Nope.
perfect. We'll talk a
Nope.
little bit about Omar here, as you just got to hear from him. He is our director of probate and trust administration here at Evans and Davis. He's Oklahoma City guy, went to OU and then Oklahoma City University Law. And he's really going to be the leader here talking about these topics. Now, for those of you who aren't already familiar with Evans and Davis, our entire firm is focused on estate planning, business planning, probate, and trust administration. And Omar is in charge of those probates and trust administration for our firm. So we have about 40 people in the office, all focused on those four practice areas each and every day. So we really like to be able to hone in and really know what's going on in those areas. So that's what you'll be getting when you're working with us. Now, we do serve clients across much of the US for our estate and business planning services. But when we're talking about probate, and like I mentioned, what we're talking about today is going to be specific to Oklahoma. So that's what we're looking at. Again, about 30 to 45 minutes of content that we have prepared for you, but please send in those questions. That's the number one thing that we want to do for you today, is be able to answer those questions for you. Without further ado, let's get over to Omar and
Perfect.
jump in.
Shelby, thank you for that wonderful introduction. As Shelby mentioned, today we are talking about the Oklahoma probate process. Now, probate is one of those terms that gets tossed around in a lot of I don't want to say everyday life, but it is tossed around a lot. And a lot of times no one actually knows what probate is, other than it means that there is an individual that has passed away. So I wanted to start off by just kind of giving a brief definition of probate. And probate, it's just a court supervised process in which the assets of the estate are determined. We determine the beneficiaries of the estate. We pay off any debts that are owed. Those are known as creditors. And then at the very end, that's when the beneficiaries are distributed what they are legally entitled to inherit. And so, as Shelby mentioned, today we are simplifying the Oklahoma probate process. I do not want to go through the probate process step by step. I don't think that would be a valuable, good use of your time. What I do want to do is I want to simplify it in a sense of, I want to take what I deal with on a day-to-day basis, the most common questions I get from clients, and I want to kind of explain those and simplify those for you so that when that time comes, you understand what you are going to be dealing with and what you may potentially be in charge of. So first and foremost, does everyone need a probate? And the answer to that is no. If there's a proper estate plan in place, or depending on how certain assets are titled, or if there are beneficiaries named, then a probate may not be necessary. So an estate plan is a trust. If there's a trust in place, then those assets that are not in the trust will need to go through probate. That is what we call funding the trust. And if you use Evans and Davis to help establish a trust, one unique thing about our firm is we do the funding on your behalf. So when you leave with the trust set up by Evans and Davis, you can rest assured that all your assets up until that time you sign the trust will be properly funded. Another way of thinking about it is the property you own will be renamed or retitled into the name of that trust. And then that way you can avoid probate with those assets. Now, if there is a subsequent property purchased after the trust, and for one reason or another, you buy it as an individual and not in the name of the trust, then that piece of property will have to go through probate. The next example is joint tenancy. Most common between husband and wife. You can do this with other individuals as well. And that is owning a piece of property or a house as a joint tenant with rights of survivorship. So what that means is if you own a house with your spouse, upon the passing of your spouse, then you become the legal owner of that house and you can avoid probate. Now, there is still a little bit of legal work that has to be done. You will have to file an affidavit of surviving joint tenancy, and that is something that we can do on your behalf. And that just states that the joint tenant has passed and you are now the legal owner of that house. And lastly is named beneficiaries. Most common life insurance policies, bank accounts, stocks, really anything in which you can name a beneficiary, those assets pass outside of probate as well. So where do probates occur? This is a question I get asked almost daily. And so the most common answer is a probate has to occur in the county of where the deceased resided. So here we're in Oklahoma, or in Edmond, Oklahoma, which is Oklahoma County. If someone passed away in Edmond, but they lived in Norman, that is Cleveland County, the probate would have to take place in Cleveland County. So it's where they resided. There are some exceptions to this rule, and those are for people who live out of the state of Oklahoma, but own property in Oklahoma. So let's say that someone lives in Arizona and they have a trust, but for one reason or another, this piece of property in Oklahoma was not included in the trust. Then they would do a probate, and they would not probate it in Arizona because there are no assets in Arizona to probate. They would have to probate it in Oklahoma. And here it would be probated in the county of where the property is located. So if there are multiple pieces of property spread out across the entire state of Oklahoma, you do not have to do a probate in every county. You would just do one. I typically choose the county that's closest to our office. We would probate it there. And then we would take a certified copy of that probate and we would file it with every other county that property is located. So that way it's as if everything is passed via that one probate. The next is if a probate has already occurred in a different state. Laws of one state do not pertain or govern laws of another state. And so here an example is, I'll use that Arizona example. If someone did a probate in Arizona, and they wanted to then pass property they owned in Oklahoma under the laws of Arizona, that wouldn't necessarily work. So we would require what we call an ancillary probate, in which we have to do a probate in Oklahoma where the property is located. And the reason this is, it's not as big of a deal if someone passes with a will, but if there is no will involved, then statutes dictate who gets what and how, and statutes of one state might give someone, say, an undivided half, whereas in Oklahoma, they might only be entitled to receive a third. And so you have to go through a probate and apply the laws of the state in which it is being probated. I do want to go over some common terms that we are going to use throughout this presentation. You do not have to try and remember these or write them down. Anytime I say these, I will try my best to remind you what they mean. The first is testate. And what testate refers to is someone who passes testate means someone passed away with a will. Then there's intestate. Someone who passes intestate refers to someone who passed away without a will. Personal representative, I will use the word PR throughout, or the abbreviation PR throughout this presentation. This is essentially the captain of the probate. They are the person in charge of gathering all the inventory, determining who the creditors are and paying the creditors, and ultimately distributing the assets to the beneficiaries. A lot of times I will talk with the client and they'll say, no, I am not the PR, I am the executor, or I am the administrator pursuant to the will. These words are all interchangeable, excuse me. And so for just simplicity, we're going to use personal representative in this presentation. Next, there's property. There's two types of property. There's real property. Think of that as real estate. So real and real. That's your land, your oil and gas minerals, houses, buildings, really anything that is attached to the land. Then there's personal property, which is also known as movable property. And this is just property that is not real estate. So it can be easily moved. Two types of personal property. There's tangible personal property, and that's property that is tangible. So it can be felt, it can be touched. This is your vehicles, a boat, a car, furniture, collectibles, china, silverware, anything along those lines. Then there's intangible personal property. Intangible personal property is property with no obvious or assigned value. It can't be held, it can't be felt. And so these are bank accounts, stocks, bonds, really most common your financial assets. Next is a creditor. A creditor is a person or entity to which a debt is owed by the estate. Like everyday life, there is secured and unsecured creditors. A secured creditor is a creditor in which a debt is owed, but they have collateral pledged against that debt. So like a mortgage or a car loan. So they would be entitled to take that house or car if a debt cannot be paid. Then there's unsecured debts. Those are your credit cards, medical bills, utility bills. So Oklahoma has three different types of probates. First is the small estate affidavit. And what a small estate affidavit is if the gross personal property is $50,000 or less, so personal meaning typically your financial accounts or just assets within the house, but most common these are going to be financial accounts, no real property, so no real estate, and no creditors, then you can do a small estate affidavit. And what that is it's just we will prepare an affidavit. It is a sworn statement, so you will swear that there are no creditors to the estate. And again, this is no known creditors. If there's a creditor that comes down the road that you are not aware of, you are protected. You will not be liable. But if there's a creditor you are aware of, then this small estate affidavit cannot be used. Next is the summary probate or a summary administration and the full probate. Now, both of these probates get us to the exact same ending point. There's just different complexities with a full probate that are not part of a summary administration. And the way you pick which route you go is by statute. And statute says if gross assets, both personal and real property, are $200,000 or less, then you can do a summary administration. And if it's greater than 200,000, you must do a full probate. So some of the similar differences between these two are a summary administration is typically about a 2 to 3 month process, whereas a full probate can be 6 months to a year, if not longer. A summary probate is one hearing, a full probate is multiple hearings, and then there's just a bunch of other steps that I'll kind of show you a roadmap here in a little bit, and you'll see steps that are not taken in a summary administration that must be done in a full probate. So preparing for an initial meeting with myself, what makes that meeting more beneficial to where both you and I can get the most out of it? And that's coming prepared with as much information as you can. And so if information about the deceased, if you can come in with their information and family information, their information specifically, were they married at time of death? If not, were they divorced? And if they were divorced, were they legally divorced? I get a lot of scenarios in which people say, oh, they're divorced, but they actually were not legally divorced. They were just separated. And that kind of causes some inheritance issues depending on how the relationship with the other beneficiaries and the separated spouse is at that time. I need to know information about the children, not just living, but also if there's any deceased children. If there's any deceased children, I would need to know if they had children because they would still be entitled to receive a share of the estate if this person passed away without a will. A death certificate. Now, a death certificate may not be in hand by the time we have our meeting, and that's okay, but it still is helpful if you have it to bring it. Otherwise, you can send a copy of the death certificate. I do not need an original, and we can work off the copy and go from there. If there is a will, I do need that original will. That must be filed with the court, and so we will need that. A list of assets, so real property and personal property, come with as much known assets as you possibly can think of. It is okay if you do not know everything. I will kind of discuss the inventory a little bit later. But if we can get a head start and know exactly what there is and what we're probating, that'll also help us determine on, do we have to do a summary probate or a full probate? Next, if you can come with a full prepared list of creditors, it helps to know what kind of debts there are. And then we can kind of start getting ahead of the curve on that as well and start negotiating those debts down. And again, I will talk creditors in depth here a little bit later in the presentation. So this is the probate process. So this, I want to emphasize, this is a kind of the 100,000-foot view of the probate process. Within each one of these 8 bubbles, there are multiple steps. And our goal here is to get to the very end where we get to distribute the assets. And that doesn't matter if that's the full probate or summary probate, that's always the finish line. Both probates start with, in the bubble that says file will, that's essentially opening the probate. And so when we open the probate, if there's a will, we must file that along with the petition to open the probate. And if there is no will, we'll just file a petition basically stating that the person passed intestate, so no will, and we will petition and get a judicial determination of who the beneficiaries are at that time. So the rest of these 6 bubbles that I did not mention, in a summary probate, these are all combined in 1 to 2 pleadings, whereas in a full probate, these are all their different steps. And each one of these has its own time period associated with it. And that's a lot of the times on what the big difference is in that time frame. For instance, notice to creditors, there's a lot of statutory waiting time there. So who's the personal representative? The PR is if someone passed testate, meaning with the will, then it's accounted for in the will. And a lot of times that they will name 2 to 3 PRs. And there is the order of how they are named. Now, the first person, if they decline to serve, or just for one reason or another cannot serve, then it would go down to the second and the third. If there is no PR that is able to serve, then we can petition the court and get a new PR appointed. And then there's the intestate personal representative. There's a statutory order here in which the surviving spouse always has the right of first refusal to serve. Then it goes children, parents, siblings, and then the most distant relative. And just like I mentioned before, if there is no one who's able to serve, we can petition the court and get another person appointed. I get calls all the time from a sibling that says, hey, I want to be the PR of my brother's estate. He passed intestate. And on the phone, we will discuss, the family situation. And oftentimes there are a spouse and children. So they will come to the meeting and they will either serve as the PR or they will waive their right to serve and just say, hey, we really do want the brother or sister to be the PR of this estate. We don't have the time or really don't want to deal with it. So it is important to note this order of priority because we can't just skip it without getting a waiver. Creditor claims. One of the most common misconceptions in all of probate is debts of the estate do not have to be paid. That is unequivocally wrong. They must be paid. So before a beneficiary can get any type of inheritance, all of the debts of the estate must be paid. It does not matter if you know all creditors or not. During the publication period, when we provide notice to creditors, if there's a debt owed, the creditor will come forward. They will file a claim within the probate with proof of the debt owed, and then we can deal with it from there. The Oklahoma statutes provide a kind of a pecking order, so to speak, of which debts take priority. And those are the expenses of administration, that meaning the cost of the probate. And now, why that is not a creditor, a true creditor, those costs get paid first because without doing the probate, no other things can move forward. So none of these other creditors would even receive funds, or beneficiaries would not receive their inheritance without the expense of administration being paid. Next is funeral cost, and then the expense of last illness. Expense of last illness is medical bills. And so the creditor claim process It's a very long and tedious process, and oftentimes can be very stressful to our clients. And so I do want to state that let us do this for you. We are here to help, and we have spent the years of our practice building up relationships with all these creditors. And so we have these relationships in place, and we can use our relationships to help talk down these debts more so than if someone were to do it by themselves. For example, I have most recently had one estate where when medical bills came out, they had $1.2 million in medical debt. They could not afford it. All of a sudden, there was nothing left in the estate. We used our relationships and we talked that debt all the way down to $2,500. And so the estate flip-flopped right then and there. It went from a spouse who was the only surviving heir receiving nothing to all of a sudden receiving everything and only having to pay $2,500. That is rare. Most times we can get up to 50%, but still, our relationships get us to the point to where we can get those settled for you in a timely manner and save a lot of money for the estate. During the creditor claim process, we will quickly determine if this estate is insolvent or solvent. And an insolvent estate means the total value of all assets of the estate are not enough to cover all the debts and liabilities of the estate. So there is no money left. So the beneficiaries would receive nothing, and all the creditors, they might not even get paid. So those first three get paid as much as they can. And if there's money left over, then every creditor would receive a pro rata share of what's left over. I do want to make it very clear that the PR or the beneficiaries are not personally liable for these debts, meaning if the estate's insolvent, the person serving or the person inheriting does not have to pay off these debts just because there is one owed. The exception to that is if they are a co-signer on the loan, then they step into the shoes and they are the sole owner of that loan. A solvent estate is opposite of insolvent. Here, there are enough assets to pay off all the debts. And then at that time, the PR can move forward with distributing the assets to the beneficiaries. So why might one file a probate during an insolvent estate? Well, Oklahoma allows for what we call a spousal election, and it's for spousal and family support. And it is viewed as a creditor. So after those first three debts, again, being the expense of administration, funeral costs, and expense of last illness, Oklahoma statute provides that a court can provide an allowance for a family. So it's a court determined allowance. And I want to make it very clear that allowance is strictly an allowance. It's meant to help maintain the surviving spouse and family during the probate process. It is not meant to have that spouse or family live off of for the next 2, 3, or even the remainder of the time. And this spousal and family election does take priority over other claims. So after those first three debts are paid, this would come before credit card bills, utility bills, or really any other debt that's owed to by the estate. Taxes. Another very common misconception is there are no taxes owed because of the estate size. So this is true and false. True on the estate tax side. So anyone who passed away in Oklahoma after 2010 will not owe an estate tax, or what's commonly referred to as a death tax. Oklahoma abolished that, and so there is no issue there. The federal estate tax, you will only owe that on the amount over the exemption. And here in 2023, the exemption for an individual is $12.92 million. So anything over $12.92 million would be subject to the estate tax. That is kind of rare that an estate of that size will go through probate. Typically, those are in trust, but they do happen. And also along those lines, I do want to state that just because an estate is of that size or smaller, there is no rule that says it must be above a certain value to establish a trust. So income tax. Income tax is completely different than the estate tax. Income tax is no different than the tax return that you and I will file on a yearly basis. Income tax returns are mandatory and must be filed for that person. It covers all income earned for the months of that year prior to date of death. This would be marked as a final tax return with the IRS. And once those income taxes are paid, then you can move forward. If you do not pay those would be viewed as a creditor. So who gets what and how? This is referring to distribution of all assets. So prior to that, I mentioned earlier about an inventory, which would help us determine who's getting what. But I do want to talk about that inventory really quick. In preparing an inventory, you would like to list all known assets of the deceased. Now that can be real burdensome, and sometimes not. It's not up to everyone to know exactly what everyone owned. And so it's not the end of the world if something is left off the inventory. We will always include what we call a rest and residue clause in our probates. And what that states is any other real or personal property located within the state of Oklahoma. So this is a Oklahoma specific rest and residue clause, whether now known or later discovered, should be distributed pursuant to the terms of the probate. So what does that mean? That means if you inadvertently left an asset off that you knew about, or if there is an asset you did not know about and you discovered after the probate, a probate's not needed for those assets. This probate will work for those unknown and known assets, and they would be distributed pursuant to the terms of the probate. So distributing assets, when someone passes testate, again with the will, it's typically very easy. You just go pursuant to the terms of the will. There is an exception in Oklahoma, and that is you cannot disinherit your spouse, meaning if someone left everything to Bob Smith, the spouse is allowed to elect against the will. And what that is the spousal elective share. So the surviving spouse can elect to take the same share that they would be legally obligated to inherit if that person passed without a will. And I will show you kind of that intestate distribution schedule here in just a little bit. But so they would be able to obtain, finances and real estate and anything like that. Well, actually, it wouldn't be real estate. It would mainly just be a proportionate share of what they would be for finances. Homestead rights. If the will left the house to Bob Smith, again, the surviving spouse has the right to occupy that house as long as it's her primary residence for the rest of her life. And in scenarios in which it is the last person to pass, if both spouses are deceased, then the children can continue to occupy the house up until the youngest child becomes of age, so meaning 18. Obviously, a guardian would need to live there, but they are able to live in that house. And once all these triggers are met, so whether it's surviving spouse then passes or youngest child becomes of age, then Bob Smith would inherit that house. I do want to make it clear that it is very important that mortgages must be paid, same as real estate taxes. Otherwise, the house would be foreclosed on. So intestate distribution, again, without a will. Statute dictates who gets what and what amount. And here statute breaks down in Oklahoma that there is a very clear distinction between marital property, which is all property acquired during the marriage, and non-marital property, which is acquired pre-marriage or during marriage by separate transfer to one spouse. Most common, that's like an inheritance. And so here is the distribution, the schedule. There are 4 scenarios here. These are the most common 4 that I see, but there are a multitude that go well outside of this. And so I do just want to run through these most common ones. On the far left column is kind of the circumstance of the decedent being survived by certain individuals. The middle column is the amount to the surviving spouse, and the far right column is the amount to others. So if the decedent is survived by a spouse only, there are no issue. Issue means children. So if there are no children, parents, or siblings, then spouse gets 100% of everything, both marital and non-marital. If there is a surviving spouse, no children, but he or she is survived by parents and siblings, then the spouse will get 100% of the marital property, but only 1/3 of the non-marital. The surviving parents and siblings will split the remaining 2/3 of non-marital property. If there is a spouse and children, joint children, meaning but the children is the biological child of both the surviving spouse and the deceased, then there is no distinction between marital and non-marital. It's a 50-50 split, with the spouse receiving half and the children receiving half. If there are multiple children, all those children will split that half equally. And last but not least is spouse with stepchildren. Here, the spouse receives half of the marital and an equal share of the non-marital, and the stepchildren receive half the marital and then also an equal share of the non-marital. So if there are two stepchildren, spouse gets half marital and 1/3 non-marital, and then the others receive, the two stepchildren will split the half marital, but then also receive 1/3 each of the non-marital assets. And so this just shows you, this is why it's very important to have a proper estate plan in place. If you do not, then you have no control on how your estate is distributed. It's going to be left up to a statute and be governed by the laws of where that probate is taking place. Here, these are the laws of Oklahoma. And so it's really important to get that estate plan in place so that you can kind of control who's going to actually get what. So next, I would like to talk about a probate alternative, and that is a quiet title. So what is a quiet title? Well, the purpose of a quiet title is it's to determine who the real owner of the property is and to put rest all adverse claims. So adverse claims are adverse possession, defective legal descriptions, ineffective conveyances, invalid liens, and to vacate easements. A quiet title has a very limited scope. It is for real property only. So again, real estate, and it's typically only good for one piece of property. It can be used for multiple pieces, typically 2 to 3 if you were to go multiple, but it's very rare and extremely more difficult. So you might be asking, those adverse claims do not cover anything in the probate process. How is this a probate alternative? The answer to that is Oklahoma statute allows a quiet title to be used as a judicial determination of heirship. What a judicial determination of heirship is it is the court saying, based on the facts we are presented, these are the beneficiaries, and this is who is entitled to take from the estate. There are certain criteria that must be met. First is the party must have died intestate, meaning without a will, owning real property in Oklahoma. Now they can have a will. However, that will must be overly broad and vague that you cannot identify any of the beneficiaries. An example of that is, I leave everything to my nearest of kin, or I leave everything to my family. The reason that this is so overly broad and vague is that's ever evolving and changing. Sometimes that grows and sometimes it shrinks. And so there is no way to tell who is who and what amount they get. And so it's very rare that a will be that vague, but it does happen. The other criteria that must be met is a period of 1 year must have taken place since date of death. So a quiet title cannot be used if the person passed away 6 months ago. It must be a full year. So why perform a quiet title over a probate? They are quicker than a probate. Typically, a quiet title takes 45 to 50 days from start to finish, and the value of real property does not matter. So here I'm going to show you a very basic example on the next slide, and I put the piece of property valued at $400,000. As you may or may not remember, that would be a full probate in Oklahoma, and that would be 6 months to a year before that could get cleaned up. So here we can get that title, that property transferred in a time frame of 45 to 50 days. They tend to be more cost effective than a probate. There's not as much time spent at the court, and there's fewer pleadings that must be drafted, and so costs are kept down. And most importantly, there is no notice to creditors. There is an exception, those being mortgages, taxes, or liens on property. They must be given notice. However, they will work with you knowing that they stand to benefit from this as well. Examples of no notice to creditors are if there's only one piece of property and there was, let's say Visa was owed $10,000. Well, then Visa is not required to be given notice because we are not probating an estate. We are simply getting a piece of property from the deceased into a new owner. So here's a very basic example. This is just one where father owned 40 acres of land valued at $400,000. This person passed in testate and he was survived by his 2 children. Upon his passing, there was beneficiaries named on all assets except this land, or he had a trust, and the only asset outside of the trust was this piece of land. So the children can file a quiet title versus a probate, and they can get that transferred over to them. So that is a very basic example. There are some very complex examples out there. I've done one recently, and I actually really enjoyed working with this family. It was a unique scenario in which family land had been passed down from generation to generation. It's gone through 7 generations. However, legally, the owner of the land was still the very first landowner ever. So this is the person that received it from the government. We call that at patent. And because it was just a family transfer, there was just all these agreements that it would always be passed equally. And so we went through the family history with them, and we avoided 25 probates and managed to do this in one quiet title. So you can see expenses were kept significantly lower because we did not have to do all of those probates. So I do just want to kind of give you a very quick probate versus quiet title, when one may be necessary over the other, or when you might choose to do one over the other. So time frame, 3 months to a year plus for a probate. Quiet title, 45 to 50 days. Creditors, you must give notice during the probate process, and in a quiet title, no notice has to be given. Property in a probate, both real and personal property, so real estate and finances. Quiet title, only real property. If there's bank accounts, a quiet title cannot be used for that piece of property. And then just the estate in general. A probate is good for the entire estate, whether you have unknown or after discovered property. And the quiet title is very limited in its scope, typically just one parcel of real property at a time. So that concludes the presentation on a probate versus quiet title. I do want to kind of answer any questions that might have come up. And so I'm going to turn it over to Shelby for the questions.
Yeah, Omar, do you want to go ahead and go to the next slide too, so people can see your email address in case they want to send over any questions that way? One of the questions that we did get was from someone who said they do have a trust set up. Will they be able to avoid probate, and when do they have to go through probate even if they do have a trust set up? Can you explain on that?
Absolutely. So when a trust is set up, yes, the main goal for a trust is to avoid probate at all costs. If that trust was what we call properly funded, meaning when you set up that trust, all assets that you owned were retitled or renamed in the name of that trust. So a house, for example, if the house was owned by Bob Smith and then Bob Smith established the Bob Smith Trust, he would need to sign a warranty or a deed from Bob Smith to the Bob Smith Trust to convey that house into the trust. He would have to contact the banks to have them switch bank accounts over to the name of the trust from him individually. So if all that has been done, then there will not need a probate would not be needed and would not be necessary. And again, I do want to state that one thing that's unique about Evans and Davis is we do the funding for you. So when you come in and sign that trust, we do all the funding. We provide letters for you to send to the banks and advise you of everything you must do that we cannot do for you. And so that you walk away knowing that this trust will avoid probate.
Oh, that's great, Omar. Thank you so much. Another question that we got in was about the time frame on probates. You had mentioned it was 3 months to a year. What makes a probate last 3 months versus it lasting longer than that?
Yeah. So in that summary part where it's say 2 to 3 months, because that's only one hearing, the hearing by statute is within 45 days of the time we file the petition with the court. And so if there are no complexities in that probate, meaning no creditors, and typically it's straightforward, then it's just that statutory waiting time. In the full probate, that can take 6 months to a year plus. Those have a lot of statutory waiting times and just tend to have way more complexities in them. So by statutory waiting times, one example is in a summary probate, when we open it, like I said, there's 45 days for anyone to come forward. When we open a full probate, where it takes 6 months to a year, we'll have our first hearing within the first 30 to 45 days, just depending on when the court can get us in. And then we have to publish our notice to creditors. And when we publish notice to creditors, there is a 60-day statutory waiting period for the creditors to come file a claim. And so that's 2 months of just sitting there doing nothing prior to even being able to think about taking the next step. And then once creditors file claims, it can often take another 2 to 3 months to get those resolved, not necessarily because they can't be paid, but we are beholden to that creditor to actually work with us and get the information we need so that we can move the probate forward. For example, if a medical institution filed a claim within the probate saying that $10,000 is owed, and let's say that it was negotiated down to $5,000 and we paid that $5,000, until that medical institution files a release of claim, we can't move forward. We do stay on top of it, and a lot of times they'll say, "Oh, our rules are we will release it within 30 days," and so that can just add in extra time. And so there's a lot of time out of our control, but that tends to be why extra time is added on.
That makes sense. That's great. Another question we had was about when, two people are married and one of them passes away. Does a probate have to happen then, or is it just after both of them have passed away?
Sure. So there is no time frame on when a probate must occur. So you do like to see a probate occur upon the passing, just because it gets everything to a cleaner point to where when that time comes, it is just easier to do the second estate. But if it is a circumstance in which a probate was not done for the first spouse, and then upon the passing of the second, we can do a joint probate and probate both simultaneously. But it's cleaner and easier for all parties involved if a probate is done. But again, there is no legal time frame on when one must be done. So if I have done probates as early as last year, in which the person has been deceased for 15 years. So it's kind of a comfort level on when someone wants to move forward. But I do encourage getting the affairs wrapped up, because it does make it that much cleaner for all parties moving forward.
Great. I think that's all the questions that I'm seeing right now. Omar, is there anything else that you wanted to share on this topic before we wrap up?
No, I want to thank you guys for spending your lunch hour with me, and my contact info is there on the screen. If you can't remember it, that is okay. Feel free to call Evans and Davis and just ask to speak to someone about probate or quiet title. You will get directed to the right person. And I do look forward to speaking to some of you, and I hope I can help you guys out in the near future.
Thank you so much, Omar. And again, just like you said, thank you all so much for spending time with us today. We did record this session, so either later today or tomorrow, I'll get that email out with a link, and you're welcome to share that with anyone that you think could benefit from watching this. We hope you have a great rest of your day. Thanks again.
Thanks, guys.